Honorable members, may I proceed by asking the nominee to give us a brief background.
92.7.
Thank you very much. Good morning, Chair. Good morning, members of the committee. I'm Quireria Akabu. My mother, the late Agnes Kwesen, is from Wasa East, Mamponso, raised in Aboso, settled at Insusaiden in the Western region. My father, Nicholas Eduaka, is from Western North. I'm the Fie and Akekrum. So from the records, I think I'm the first nominee to come from the Western North. And for the Western region, I'm actually the third nominee from the Western region. I had my secondary education. I started from St. Augustine Secondary School at Bogoso in the Western region. I left there after 2.5 years, came to Winneba Secondary School in Isekwe. I had my O-levels. I had my A-levels at Secondary College. From there, I did my national service at Aboso in the Western region. Came to University of Ghana, Legon. I was a resident of the Commonwealth Hall. I went through with an LLB degree. From there, I went to Ghana School of Law. I was called to the bar in 1996. I did a brief practice. I did my pupillage at Bosonchi Salmon Associates in Takoradi. From there, I joined my brother, Ben Akajesi, to start Kendrick's law firm. In 1999, I left Ghana. I went to Erika's Training Institute for Human Rights and Public Administration, University of Helsinki. I had my LLM there. I was then enrolled in a licentiate program, which was towards a PhD, but I didn't complete it. So I migrated to Canada, where I enrolled at the University of Ottawa Law School for my pupillage. I was called for my post-Canadian bar. I was called to the Canadian bar as a barrister and solicitor and notary. And I practiced law in Toronto, Canada as a criminal defense counsel. I also appeared before many of the other courts, the federal court, the superior court, did many work there. In 2015, I was appointed as a justice of the High Court, 1st April. I spent 7.5 years at the High Court. In December 2022, I was elevated to the Court of Appeal, where I have continued to work till now. I am married to the beautiful lady behind me, Joycelyn Kuku Akabu. We are blessed with 2 children, Nick and Maud. I'm a born-again Christian, a member of the Full Gospel Church, and grace has found me. I call myself a PGG. I'm a product of God's grace. So I am here today to be vetted for the Apex Court of Ireland. Thank you very much.
Thank you, nominee. Our members will then proceed to take questions. I will start with the subject matter committee members, and I'll call on Honorable Bitsidi to start.
Thank you very much, Honorable Chairman. Congratulations, my Lord. I have a few questions for you. The first is, my Lord, are there enough lawyers in Ghana? And if your answer is no, what do you think can be done to increase the number of lawyers in the country? Thank you.
Thank you very much, Mr. Chair. Well, at the last count, the information I got, because I teach at the law school, is that between 1877 and 1963, there were 570 lawyers in Ghana. And I mentioned 1877 because of the Judicature Act. But from 1962 till now, as of May 2015, as the last call, I think the lawyers from 62 to May 2025 is about 10,400 and something. So in effect, many lawyers or lawyers in Ghana in total would be about 11,000 something. From the Ghana Bar Association portal, as I asked around, you see practicing lawyers will be about 8,000 to that extent, there are not enough lawyers in Ghana, because if you look at our population, then you have about 2,000 people to a lawyer. If I compare it to Ontario, in 2020, the Ontario population is 14-point-something million with over 56,000 lawyers, which will be about 1 to about 7,700. So to that extent, no, there are not many lawyers in Ghana. So I think that something ought to be done. What should be done is for something for discussion. And you asked me what should be done. I mean, at this stage, we know that the Ghana School of Law that train lawyers. There have been conversation that the institutions that train the LLBs should be allowed to do the professional. I will hasten to add that we need to be very careful how we do that. Because if many of the LLB schools producing candidates, the question to be asked is, do they have the requisite material and the qualified lecturers to teach there? Because let me say this. If you produce, let's say, 100 graduates, and they write the entrance exam as it exists now, and you don't have more than 10 people passing, then I think there's something wrong. So yes, we should enlarge it, but we should be very careful, because after LLB, somebody must do pupillage. Do we have qualified chambers to train the lawyers who will qualify? If we have over 8,000 lawyers and there are only about 1,200 registered chambers, there will be a problem. But yes, there's a need to enlarge the number, but it's a conversation that should be had deeply and without any emotions. Thank you.
My Lord, we know your background. As a lecturer, you can be lecturing for the whole day, but we don't intend keeping you for the whole day. So I humbly plead that we observe the brevity principle and short answers will be given to questions.
Thank you, Mr. Chair. Very well noted.
Yeah. Any further question?
Thank you, Mr. Chair. I have no follow-up question, but I have a second question for my Lord. My Lord, there is a troubling trend of people using social media to abuse or defame other people. Some hold the view that suing them and awarding damages against them amounts to curtailing freedom of expression. Do you agree with this position, my Lord?
Thank you, Mr. Chair. Mr. Chair, the Venerable Justice, a well-known justice known to everybody who has studied the law, the name just escaped me, from Britain, and I'm sure by saying Venerable, all of us remember him. In the case of British Steel Corporation versus Granada, said, Lord Denning said, freedom, if you want to deserve freedom, the press deserving freedom, they must work for it, because free speech is not taken. In Pakenham and North Carolina, Justice Scalia said, acting on social media, it is like the old style writing in newspapers. Therefore, there must be some guidelines there. So if you go on social media and you use that to abuse somebody, and the person thinks that he's defamed, I think that going into the court will not be gagging anybody. There must be responsibility. People must be responsible on social media. Thank you.
Any further question?
Yes, Mr. Chairman. No follow-up question, but I have a third question. My Lord, my final question to you is that some people argue that the practice of empaneling judges by the Chief Justice allows the Chief Justice to favor certain judges for particular cases. I'm talking about in the Supreme Court. Do you think something should be done about this particular situation? Thank you.
Thank you, Mr. Chair. I think the Chief Justice and paneling judges is an administrative work. But the question you pose also gives me the impression that there's that perception that a Chief Justice can use that negatively or select something. My view is that we should have a statutory legislation about electronic empaneling. Even at the Supreme Court, there should be panel heads with the Chief Justice as one of them. Because my understanding is that at the appellate court, there are senior judges, middle senior judges, and junior judges. So that if you have panels of, let's say, 4 at the Supreme Court, with the most seniors as the heads, and cases are assigned electronically, and it goes to panel 1, which is headed by Judge A, then it cannot be changed. It will help to take away the perception of abuse of a Chief Justice using paneling to do favoritism. That will be my answer. Thank you.
Any follow-up?
Mr. Chairman, there will be no follow-up. And my Lord, congratulations, and I wish you well. That will be all for now.
I'll proceed to give the floor to Yaoboma Jr.
Thank you very much, Mr. Chairman. Congratulations, my Lord, for the elevation. My Lord, I believe that when the bench is filled with incompetent judges, they will deliver low-cost decisions at the expense of the citizenry that we represent. In your view, how do we monitor and eliminate incompetent judges who see the bench as a benign retirement from the rigorous private practices that we have?
Well, thank you, Mr. Chair. Incompetent judges, I think that to be elevated to any of the benches, individuals go through processes. So once they are appointed, they are presumed to be competent. Now, the judiciary certainly has an assessment section that they assess judgment. I work at the JTI. There are times that a judge may err, that a reference may be made for judges to be retrained at the JTI. And I think that is one means of assessing whether or not people's knowledge in a particular area is not good. But we know the rules for appointment. Once the person is qualified and it's a lawyer and it's appointed, there's a presumption of competence. And so it is just an issue of building capacity. Thank you very much.
Follow-up, Chair. The conversation for the Ghanaian people is justice delivery that seems to accord to the benefits of the people we represent. And so it is not just only a matter of the appointing process, but a form of assessment that assures us that judges, whether in their promotional whatever, is based on competence. So from the Supreme Court that you are going to, what are some of the recommendations in terms of monitoring to establish that competency outweighs any other consideration for appointment?
I honestly believe in an independent judicial commission for elevations and appointments. And that commission, if it's put in place statutorily, will then consider some disappointment. They will assess your work, they assess what you've done, what you are able to do, and that will become the basis. And by the way, in other jurisdictions, you can't even be a judge without voluntary work that you have done, for the community to see that you've served them prior and you can serve them on the bench. So I think that that's one way of assessing competence. Thank you.
Honourable members, as we want the nominee to be brief, we should also be brief in setting the foundation for the question. I'll give the floor to Awa Bafo.
Congratulations, my Lord.
2.7.
Chairman, with respect, not to chip away your powers, but I plead with you to allow things to flow.
My Lord, you stated that the population of Ontario is 14 million and they have 57,000 lawyers. 56,000 lawyers. The size of the Ontario economy is $887 billion. the size of the Ghanaian economy is $8.83 billion, $82 billion. Don't you think that the demand for lawyers in Ontario is driven by the size of their economy as opposed to the population of Ontario?
Thank you, Mr. Chair. I think that is part of the analysis, but the Ghanaian economy figure you just gave also call for judges in this nation. Let's be honest. In my father's Western North, I'm not sure they have more than 5 lawyers there. And it's a regional capital now. You have lawyers work there. So I think that there's a need for that increase in our space as well, because businesses, district assemblies, and private individuals certainly require the services of lawyers. Thank you.
I'm going to ask a follow-up. My Lord, in the 80s, one of the busiest places for legal practice was Western Region, particularly Takoradi and Kumasi, because the economies of these places were booming. And so legend has it that some of the best lawyers, in fact judges of this country, practiced either in Kumasi or Takoradi. And at the time, their population was very small. And so, by way of follow-up, don't you think that the emphasis really and truly is more on economy than the size of the population?
Your contention is right, but you also recognize that for some time now, Ghanaians have become aware of their rights. I mean, look at growing up, there were only few high courts. They were only based at the regional capitals. Now high courts are district capitals and other places. If the courts are there, people understanding their rights will go there. And sitting as a judge, knowing that somebody self-representing is one of the challenges any judge will face. So I think the economy is a consideration, but the population as well, knowing that they have somebody who can advocate for them is also very important. Thank you.
Well, Honorable Imie, you have the floor.
Thank you, Mr. Chairman. Congratulations, my Lord, and welcome to the committee. My Lord, we'll start with judicial integrity. You would agree with me that judicial integrity is very important to sustain the confidence of the public in the judiciary. Can you tell this panel, how have you, as a judge since, I think 2015, when you were appointed to the bench, maintained your integrity? Thank you.
Thank you, Mr. Chair. I think the judiciary, I will call it the arbiter of the nation. And therefore, the presumption is that when people have been entrusted with power to administer justice, they ought to be ethical. Judges have code of ethics, and that is what is supposed to guide us. How have I done mine? I think that I find this as a fulfilling opportunity to serve this nation. And to serve the nation means that I must try to be unashamedly ethical. And being ethical means that you guide your integrity in doing your work. Thank you very much.
Now, as a justice of the Court of Appeal, if you should discover misconduct from a fellow judge, how would you approach that?
Well, if it is a misconduct that calls for a report, certainly I think that even as lawyers have obligation to report their colleagues who are caught in misconduct to the General Legal Counsel. As to whether or not they will do it is another matter. Because anytime I pose this in classroom, the student go, no. So, but if I see a judge in a situation like that, which calls for a complaint, I think I will speak to a senior judge about it. And if it is something that can be resolved without making an official complaint, that will be done. If it ought to be officially complained, I will do that. Thank you.
My Lord, in your view, we're going to a different area, AI. In your view, as a justice of the Court of Appeal, do you think the judiciary is prepared or poised to use artificial intelligence as evidence in the determination of cases, considering the fact that these days it's so easy to generate anything?
I will highly recommend the judiciary to be AI literate. The judiciary of Ghana must endeavor to make the judiciary AI literate, because that is the new trend. However, we need to be very careful engaging this, because if we are all literate and as to how it operates, then we are in the front end and then we'll be able to know the dangers associated with it. Many countries like Canada and UK have guidelines for judges. And so whilst I recommend that AI literacy should be embraced by the judiciary, then we'll be required to have guidelines to guide judges, so that when lawyers are found in processes with hallucinations, we'll be able to know it and address it. Thank you.
Now, my final question. I believe you are familiar with this statement. It's been in the media for quite some time now. The packing of the Supreme Court by the President of the day, unquote. Do you think that President Mahama is packing the Supreme Court to secure political advantage, or you think that you are being sent to the Supreme Court to deliver justice according to law?
My answer will be the latter part of your question, but on the issue of capping, I will respectfully ask this committee and this House to, before you talk about numbers, look at the jurisdiction of the court. Because the court has over 8 jurisdictions. The last time I checked, with respect, Ghana may be the only country with a Supreme Court which sits every week. In Canada, the Supreme Court sits in sessions, winter, spring, and autumn. So they sit and they don't deliver more than 65, they deliver between 65 and 80 cases a year. They receive over 500 cases. They do filtering. And at the end of the day, they may accept about 120 and they will do about 65. So before we talk about numbers, let's look at the jurisdiction. And with that, let's try and give some of this jurisdiction to the Court of Appeal to deal with it. And then we can talk about numbers in regards to the Supreme Court. Thank you.
I'm very grateful. Mr. Chairman, I'm grateful. Just that from his CV, it's not a question. From his CV, when you look at hobbies, I see he's indicated that he enjoys singing. We were in the same hall, Commonwealth Hall, and I never saw him in the choir.
So everybody that believes in singing must be a member of the choir. Honorable Tampuli, you have the floor.
Thank you, Mr. Chairman. My Lord, you are welcome and congratulations.
Thank you.
See that you are a VMate, I would have asked you to hold something, but it's all right. We'll do it another day. My Lord, taking a cue from the question that was asked of you about empaneling by the Honorable Bitzidin. Now, there are a long line of cases which deals with especially the rule that the person shall not be a judge in his own courts. And from the cases of Attorney General versus Salah, Kwashi Haidan versus Akufo-Addo, Bosin and Apalu, and so on and so forth, all the way to the recent cases. You see that the issue GBA versus Archer and so on and so forth, and Urban. Now, those cases have arisen because the Chief Justice, maybe his powers or decisions are being contested, and he is supposed to be the person empaneling the courts. Now, your proposal that we should digitalize the platform is a very, very innovative one. Where do you think the Chief Justice would be in such matters like this? My Lord, the Chief Justice, the acting Chief Justice is sitting right behind you. I'm not too sure if you are depriving him of something by digitalizing the Empaneling platform.
Thank you, Mr. Chair. As I indicated, it's an administrative function of the Chief Justice. But we also live in a society where perception counts. Because anybody, even lawyers, will ask that why is he the person at the end of it and is the one appointing judges? So that is why I think of such a proposal. The CJ, him or herself, will be maybe a panel head. But in a situation like that, his or her panel cannot hear the matter. And the matter could be assigned to the other panels which are established. So I think it's something that we ought to look at, because if people perceive that using your powers to administrative and panel leads to a favoritism, sometimes sidelining some judges who ought to sit and are not sitting, and others are being overburdened, I see this as one way of solving that problem. Thank you.
Thank you, Mr. Chair. Mr. Chair, I have a quick follow-up. So under what circumstances would you recommend that the Supreme Court, for instance, departs from its earlier rulings in respect of that subject matter, that if a statute says that the person should sit, the person should sit, the doctrine of necessity and all of that? Is there any other circumstances that you see that the Supreme Court can depart from that? Thank you.
Sorry, is this in line with empaneling?
That's right.
Yes.
That is so.
I think that we live in a society now where many of my colleagues are doing further education. People have specialized knowledge. I have on my own sponsored myself to World Intellectual Property programs yearly, and insolvency programs. So if you have a judge has a particular expertise in an area, and there's a subject matter that law judges' expertise will help, that will be one of the exceptions, because then we'll help develop our jurisprudence. Thank you.
Shall I thank you? Congratulations. VMate. Sharp.
After sharp, what is it that you cannot add? Honorable Omar, you have the floor.
Thank you, Chairman. My Lord, congratulations. I have my question is in reference to the constitutional review. At least we've had the Constitution since 1992. If you were to submit a question or a suggestion, what will you do? What will be the suggestion to the Constitutional Review Board?
Thank you, Chair. I think the first thing, I seem to have mentioned it when I was asked the question, I will seriously recommend that we should have an independent judicial commission for purposes of appointment, and as it exists in Kenya and other places, so that people who are qualified, be they sitting judges or those in private practice, can apply. They assess your work. Once they filter it through and they think that you are qualified, it then goes to government, which will not have any control over the candidates presented. So that would be one thing I will recommend. The second recommendation, again, would be, I will also suggest that we do receive complaints against Superior Court judges. My recommendation would be that the reform should include the fact that if a petition is filed against a Superior Court judge to the President and is given to the Chief Justice, the Chief Justice should give that petition to the three most senior justices of the Supreme Court. The Chief Justice should not make the prima facie determination. The three most senior justices of the Supreme Court should be permitted to assess that petition, and their decision, if the need for committee, will be set. Otherwise, is dismissed. These are the two things I may think. And also, we may want to have a police independent commission to assess complaints about police officers. The police should not have the opportunity to, that is law enforcement, should not have the opportunity to sit on complaints against police officers. This will be some of the recommendations I will make. Thank you.
Thank you so much. I don't have a follow-up. My second question would be on what areas will you suggest as a judicial reform to ensure efficiency and reduce delays?
I think, Mr. Chair, thank you. I think it might not be much of a reform, but building capacity of judges should be something that we think about. We are asking questions about incompetence and so on and so forth. I think judges' capacity should be built. And that means that we should be able to provide financial support timeously to the judiciary. I work as a partner of the JTI. The director has many programs, but there's no money to train judges. So I think that must be done. Just imagine you being paid in June 2025, the last quarter payment of fuel for you in 2024. So I think that the financial support ought to be given. We're talking about helping to avoid delays. We need to take a look at our rules. Some of the civil rules must be looked at. Recently, there was a provision in regards to juries. Let me say this. The jury system is a good system. The whole idea is that your peers have listened to your case and they have ruled on it. Can we have a statute where every Ghanaian of 21 years' name can be on the list of jurors at district assemblies, so that private individuals, everybody can be a member of a jury, rather than public servants who are the only ones who are chosen? And when the pool is basically enlarged, you have many people who will be willing to serve as jurors. And it's one way of enriching it, and let us have criminal matters day-to-day trial dates, so that when we start a trial, you should not be dealing with a criminal matter with a jury from 2022 in 2025. Let's have a system where criminal matters we start and we can complete timeously. Thank you.
Thank you so much. I think I like the jury system because I've ever served on the jury in the U.S. Jersey City. My last question has to do with this fear of tribunals. The NDC government wants to reactivate the tribunal, the government of the day. It's in the Constitution, but it looks as if it's not being used. It's here. It's 142. 142. Constitution is here. And I want to find out if it is legal, why do they have this fear? Thank you.
Mr. Chair, the honorable member asking me to assess why people have fear. Fortunately, I will not be able to find out why people have fear. The reality is that it's part of the law. It has not been used for some time now. It is being set up to deal with, we cannot shy away from the fact that we have delays in our system. Is it being brought to help clear this delay? Is it being brought to be given specific jurisdiction to deal with certain matters? I think it depends on what is the policy rationale in wanting to bring this. If that policy rationale is anchored in law, I do not think that anybody would be opposed to it. Thank you very much.
Thank you, my lord. I think it's coming to address the backlog and the delays. Thank you so much, and I wish you well. Congratulations.
Honorable Patrick Yauboma, Senior, you have the floor.
Chairman, just to congratulate you, I don't have any question for my lord. I don't have any question for you. Congratulations. Thank you.
Thank you. Thank you very much.
Thank you. I'll proceed to give the floor to Honorable Haji Aladi Ayamba. You have the floor.
Thank you, Chairman. Congratulations, my Lord. I have just 2 questions. One of them is about the retirement age of judges of the Court of Appeal and then the Supreme Court, which currently stands at 70. I have heard from certain quarters that we are thinking of 75. What is your opinion about it? And if you've heard it, that's if you are aware.
Thank you, Mr. Chair. I think I became aware through question of my other colleagues here. The reality is this. I think I do not have any statistics, but indication that people retire at 70 and within a short time, they join the other side. The work of a judge is a stressful one. You burn the midnight oil, you sit up and write judgments. So I think that 70 is good enough. And let me say, even in other jurisdictions where they have 75, when you are about hitting 70, you can choose to be a supernumerary, which means that you've cut down your work, you choose what to do, and you'll rather give it to those who are young. So as my brother who once said here, I think the 70 is good enough. Let's stick to it. So that when we retire, we can have time to spend with family. Thank you.
Chairman, my second question is about our districts with courts and the lack of judges. I think this is about my 3rd time of asking this same question. What is your suggestion on how we will be able to get judges to, I should say, the 216 or is it 17 districts as at now, so that we don't continue to delay cases, denying justice to people?
Thank you, Mr. Chair. I think the occupation of a judge work must be attractive. There are many lawyers who may desire to be judges, but if you join the bench and after 6 months you've not been paid because your name has not gone on the system, within that 6 months of your service, how are you supposed to support yourself? So let's make the job attractive. As we speak, my beloved Bogoso has a court yet to be inaugurated, and I'm sure the people there are yearning to have a judge. But if people are not willing to join the bench because the package is not attractive, speak with those on the lower benches. Their situation is not the best. So let's make the job attractive, and I think we'll be able to have the best of the brains to join the bench for the benefit of our nation. Thank you.
Thank you, Mr. Chairman.
And CD are picky, meaning another gargantuan price drop on top of all our existing discounts on Samsung, TCL, Media,